Thank you. Mr. Salucci, good morning.
Good morning, Your Honor. May it please the Court, my name is Guy Salucci. I'm here with Shane Heskin, also of Lloyd Williams. It's our privilege to be here today representing Century Indemnity Company. As this Court recognized a few short years ago in the Chesterton case, it has never had the occasion to decide the issue between the all sums and a proration approach to allocation and in a situation where property damage or bodily injury has happened over a lengthy period of time. The First Circuit has now extended that invitation in our case, which dealt with a manufactured gas plant that started operation in 1908 and operated for approximately 60 years with various leaks, spills, and releases.
Could I just ask you this question? Because obviously the questions put to the jury only dealt with, was it 51 to 69?
Yes, Your Honor.
But the record, that's in the record that the releases were from, what was the date you gave?
1908, Your Honor.
1908 forward.
Yes, Your Honor. It's a fair reading. I'm not sure Boston Gas will concede that, since they make the point that the jury only found, but the jury was only asked
right, I
whether
understand
property
that,
damage
but
happened each year.
that's why I was asking.
Yes.
It, but it is in the record.
Both sides' experts testified that the releases would have started within days or weeks of the operation. So I think that's a fair reading. And certainly would have continued after the last policy, because if the pollution had stopped, they wouldn't need to clean it up in 2005 or whenever it was finally cleaned up. So obviously it didn't magically stop. At any rate, it is a unique set of facts, or I shouldn't say unique set of facts, given pollution cases. It's pretty common that pollution goes on for a long period of time without being discovered. Here, Boston Gas seeks to collect all of their recovery for what was 100 years of pollution from a single policy, as if it had actually happened all during one policy period.
Up to the policy limit.
Pardon?
Up to the policy.
Up to the policy. That's correct, Your Honor, but all within one single
Sure.
policy, as if it happened in that 1 year. That all sums approach has been proven wrong for a number of reasons. First and foremost, it is inconsistent with and has no support in our actual insurance policy, and I'll take you through that in a moment and hopefully show that. It could not have been a reasonable expectation of Boston Gas, and it is an approach that has been widely criticized as not really answering the allocation issue, but merely postponing it and creating a lot of other issues and more questions than it actually answers. As a result of those problems, 7 out of the 8 Federal Circuit Courts of Appeal that have addressed this issue since Keene have rejected all sums. And as Judge Boudin recognized in our case, a growing plurality of state high courts have also rejected it, including the last 6 out of 6, among them New York, Connecticut, New Hampshire, and Vermont.
Would you agree that I think this is your argument, that one of our appeals court cases, Chicago Bridge, aside from the fact it's Illinois, but your policy is very different from that. That's
exactly, Your Honor. In fact, I think Chicago Bridge supports exactly our proposition, because in the Chicago Bridge case, the insurance carrier there in London, and it was a foreign London forum that was at issue, London argued that there were 2 lines of cases in Illinois, one of which found all sums, and it was an asbestos case, and the others found pro rata in environmental cases, and they tried to say the distinction was asbestos versus environmental. And Chicago Bridge said no, it's the subtle differences in the language. In the environmental cases, they had language just like ours that said the policy was limited to the property damage that took place during the policy period. The London forum that was dealt with in Chicago Bridge had just the opposite language. So Chicago Bridge, we feel, supports our position. We tried to demonstrate on page 2 of our reply brief, where we replicated the insuring agreement, exactly why the all sums reading is wrong. It actually strikes out an important phrase from the policy. The insuring agreement says, first you'll note, it doesn't even have the magic all sums language, which some courts have said have created this impression, this reasonable expectation on the part of the policyholders.
Your argument is not going to hinge on that, is it?
It's not solely, Your Honor, but if you're talking about reasonable expectations...
You're saying the essence of this is not all sums?
It's a minor point, but you can't have a reasonable expectation based on words that don't exist in your contract. But the key point is that we agreed to indemnify for ultimate net loss that they became legally obligated to pay as damages because of property damage to which this insurance applies. None of the all sums cases talk about that phrase at all. They just jump over it. It disappears from the opinions. What also disappears is the policy period territory, which was on the very next page of our policy, that succinctly said this policy applies to property damage which takes place or occurs during the policy period. If we insured under this policy property damage that happened before the policy and after the policy, we wouldn't need a policy period in the first place. It doesn't add anything. And as this court recognized in the Hakeem case, if there's two readings, one of which gives import to all the words and phrases, and one of which overemphasizes certain words to the exclusion of others, you should adopt the reading that gives meaning to all the words and phrases, which is exactly what the pro rata does. Now, the other problem I wanted to mention that with pro rata or with all sums is, again, it could not have been a reasonable expectation. The way people understood policies back in the 1960s or 50s when Boston Gas purchased this, and before the claims made advent of policies, was your policies covered a defined period of time. When you bought auto insurance, it covered the loss during the period the policy was in effect. And you, as the policyholder, had the obligation of coming forward with those facts to establish the accident happened during the policy period. And if you wanted that right fender fixed, you had to show the right fender was damaged in the accident. And that was a burden on the policyholder. What the courts have done in these difficult asbestos and environmental cases is recognizing that 80 years or 100 years later, you can't really say exactly what happened during each policy period. They've taken the burden off of the policyholder to show the specific damage that happened, and that's why courts allow continuous trigger or injury in fact trigger that recognize damage happens over a long period of time, but the policyholder doesn't have to prove exactly what happened during our 1966 policy. But it's one thing to relieve them of that burden. It's another thing to let them pretend it all happened in 1 year, which is a complete legal fiction.
Well, I mean, that isn't how they would put it. Right, I mean, if it's to pay, you may be right that they would say to which this policy applies doesn't mean what you say, but if it's all damages...
It's all damages because of the property damage to which the insurance applies.
No, I know,
right.
but it's not entirely a fiction.
Okay. But at any rate, it's something normally would be their burden. It's fine to relieve them of that burden, but if you're going to do that, then that's why most courts then adopt as a default or a presumption that the damage happened fairly equally over time.
Could I ask you this question? Under a pro rata approach, what do you do about future cleanup costs?
Well,
or are they all done? I mean, I'm just not clear what happens in the future.
we would say that all of the obligations that arose from this pollution, which we know where it is now, et cetera, and it's been remedied, but all of the damage from that resulted from about 80 or 90 year period of time between the start of the operations until it was discovered. So we would say manifestation is generally the last policy that is the cutoff period. So the period between when it first started and the period when it was discovered would be the period that the loss would be spread over.
But in the case in the federal district court, I thought there was some order that goes forward.
Right. There was a future investigation that was going on at the time of the trial that there might have been an impact into the, I think it was the Mystic River. And
So we're not
nobody
talking
knows
about-
about that.
Okay.
So whether that has to be remedied or not. So the point was the judge was giving broad relief that anything else that happened to the site, we were responsible for.
All right, but so what I want to ask you is, assume a pro rata approach. What happens? Same facts, but you apply a pro rata approach. What do you do about that? What do you do about that?
If that was all the result of the operations, then it would be the responsibility of the period of time between the start of the operations and the point in time when that damage was discovered, because it hasn't been cleaned up and it's continuing to damage.
So then would you adjust whatever your damages were?
You would adjust the period in which the damages are spread, exactly. I think I'm saying the same thing.
Okay, right.
So
I take it as a factual matter in this case because the total cleanup costs, or total damages, I don't know if they're cleanup costs, are lower than the coverage amount here, if we agreed with Boston Gas, only essentially would be on the hook, not anybody else.
Well, as an initial proposition, but it wouldn't be fair to Century. We only insured...
I'm just trying to understand. So
right.
they choose anyone. I take it there were other insurers that have been identified and the
Yes.
policies reconstructed and so on and so forth. So there are other people.
There were
Other
two other
institutions.
carriers who settled the case and did not participate in the trial. But that's a whole different issue. If you were to follow the all sums, which again, there's no basis in the policy to do that, but if you were to do that, we would have to go back and retry the entire case, only this time we would be standing in Boston Gas's shoes to show there was property damage during the London period, which was earlier, and the Aegis period, which was later than our policies, and that those policies were triggered and applied to the loss. And then somebody would still have to figure out, well, how do we apportion among those three carriers?
And you'd also have to face the proposition, I take it, if those are the two that have settled, right?
Yes.
That they would say, you can't come after us.
Oh, they absolutely will take that position. That's why I said we'll have to try a whole new case over again that is a duplication of what Boston Gas tried against us.
But I mean,
If you
they're
can
saying
get
you
past
can't
them.
come after us under the contribution law. Is that...
I think, I don't believe they're saying that. They may say that they've settled. Boston Gas, I think, is arguing that we can't come after them because they're saying you can't really apportion the settlement
No,
amount.
I understand that. Justice Watson is going one step beyond. If you had to go against the other carriers, they would file a motion to dismiss.
They would, but there'd be no basis for it, really. If their policies, the policies would have to respond because they had insurance that covered some of the property damage that took place at the site.
Of course, the interesting thing is that the all-sums approach is based, at least in part, on a joint tortfeasor theory, and if one of the joint tortfeasors settles out, they're gone.
Right. That's what I'm saying.
But there are principles that no court has said that the court that's chosen cannot get contribution or indemnification, depending on the case as it may be. There
You
are
may get
equitable
credit.
subrogation period.
We have a statute, at least to the extent that that it's defined as a tort theory as opposed to a contract theory. We have a joint tortfeasor statute that once a tortfeasor settles in good faith, they're out of the equation.
Your Honor, I think you're confusing the difference between there's a tort theory under which Boston Gas may have been liable. We would be liable under our policy only on a contract basis.
Yeah.
So we would have at least equitable subrogation principles, if nothing else. But I think contribution...
No, all I'm saying is that the all-sums approach is muddied up by the interjection of the joint tortfeasor law.
Yes, it's muddied up by a few things. But again, our policy says it's the liability they incur because of the property damage which happened during our policy period.
Mm.
Here they picked the 66 to 69 policy period. They certainly have incurred lots of liability. Lots of the $6 million that was incurred to date, or 6.2, whatever it was incurred for pollution that happened back in the teens and 20s and 30s and 40s and in the 70s and 80s. It wasn't just because of what happened during our policy period. And that is the loss that we insured. This is like a series of auto accidents that happen on either side of the policy, and because you have one under the one policy you want to pick, you're going to try and put them all in the same policy. Just because you have a lower deductible or something, it can't be done. It shouldn't be done, and that's why the vast majority of courts that have sat down and looked at the big picture and all the language of the policy have come to the conclusion. That's why there's a growing plurality. The last six, all four of the sister states of Massachusetts that have identical insurance interpretation laws have all rejected all sums as not consistent with the language of the policy and not consistent with the facts. The only other thing I was going to mention is the Rubenstein case, which, again, it was not an issue raised at the trial court. The trial court was confronted with the issue of if she did not permit a settlement credit, the policyholder may have recovered more than they were out of pocket, which would be an unwarranted windfall. It was then raised for the first time on appeal, and all I can say, it wasn't a fully developed record. There was no real discussion of the policy language, and the court didn't have the benefit of the last 10 years of jurisprudence, which has pretty much been an avalanche in favor of an all-sums approach.
Now, you also take the position that I think that for years in which there was no insurance coverage, the insured is responsible for or its pro rata portion of those years,
That is our
or
position.
attributable by those years. Yeah.
That's our position because they chose to self-insure. Even in our years, they chose to self-insure at the primary level. Rather than purchase primary insurance, they entered into self-insured retention agreements. We wrote only excess catastrophe policies above what was supposed to be a primary level, but was a level that Boston Gas said they were going to honor. So they said they were going to take care of the first $100,000 of loss each year. And they even argued that at trial because at one point there was a late notice issue and they were arguing their defense, why didn't they report the claim? Well, they didn't think it was a big claim and they had the first $100,000 of loss.
So your argument is that you insured for what, 10 years or more than 10 years?
Pardon?
How long was your policy
Well,
in
we
effect?
had several policies. The jury found
Right.
there was a loss policy that went from 1951 to 1960. There was a second
About
policy
18
from
years.
60 to 66. The third policy was 66 to 69. The third policy was a $17 million one. The earlier ones were $1 million.
So let's say on an apportionment basis, let's say the cost of this cleanup ultimately is $20 million. And so we look at it over 60 years and we divide it out and it's, 300 and something thousand a
Yes.
year.
We,
all right.
we would say we did not pay the first $100,000, but we would pay the $200,000 above that for each year.
Oh, so you would use one retention,
For each
not
year. No, one retention
a
for each
one
year.
retention for each year.
Yes, because, again, this is like a series of auto accidents that we're pretending is one. So there was property damage, there was soil contaminated, there was groundwater contaminated throughout the 50s and the 40s and 30s and 20s. And that's what was remedied. It was the cleanup of that entire amount. It wasn't just what happened during the contractual period that we agreed to indemnify them.
But I thought continuous exposure is, right, that's an occurrence, right? So it's not
Your
like
Honor,
an,
that's a
not
good-
like an automobile accident.
No, that's a good question because I think some of the courts have confused. There are two different issues.
But the reasonable expectation of the parties is that they would pay the retention every year.
Yes.
The insured would pay the retention
Yes,
every
but
year.
If I may answer Judge Cordy's question, you need some property damage during the policy period that was unexpected and unintended to have an occurrence. Once you have an occurrence, the policy is triggered. You then look at the insuring agreement, which is what we set out in page 2. The insuring agreement says how we respond to an occurrence once the policy is triggered. And we say the way we respond is we'll pay all your liability because of the property damage that happened during the policy period, because that's the only property damage that this policy applied to. That's why we had a policy period territory that said that.
Could I ask one question?
You may.
You probably said this and I missed it because I was long on Rubenstein, but if we adopt the pro rata approach, you say we don't need to answer question 3, is that right?
That's correct.
So just tell me under a pro rata approach, what happens to the self-insured retainer of each year?
Well, the policyholder would be responsible for the dollars that fall in that. What a pro rata approach does is says, okay, we've got $20 million of damage. We don't know exactly how much happened in each year. We're going to treat each year basically equally. So then, if make math simple, let's say it's 5 years, you're going to say $4 million of damage happened in each year.
Right.
Well, who has the first $100,000 of that year? In our case, Boston Gas did. We had the money. We had the money above that.
So they
So-
paid,
They would pay the first $100,000 each year.
Of
We would
each
pay
year.
the balance above that, depending on what.
So for your
how the math
18
works
years,
out.
you would, I mean, if the SIR is 100,000, you would take off 100,000 each year. So you'd reduce that by $1,800, or, I mean,
Be
whatever that
$1.8
meant.
million
1.8
roughly, but
million,
yes.
yeah.
But that's surely not the only way that it could be done. You could
No.
be liable for 18 out of 60, whatever the percent is.
Exactly.
And apply to a single policy with a single retention. So in other words,
For-
if there's
for
60
that-
years
for
and you
that
had it for
damage.
18 years, you're, whatever the percentage is,
1/3.
1/3. So you're liable for whatever it is, 1/3 of the total. And as
Yes.
opposed to applying it year to year to year, you would then be able to take a single retention.
But I don't understand the logic of that, with all due respect, Your Honor, because that's, again, pretending it was just all one auto accident or something, which, again, I think if you read
Well,
Judge
there are
Boudin's-
fictions in all of these. The question is how much fiction and which
Right.
fictions are we
Right.
going to
It-
adopt that are most reasonable in
You're
the
right.
circumstances.
There's some logic that I don't think that's the correct logic, and I think Judge Boudin found that was the biggest fiction, to pretend this is all really one occurrence and one, so to speak, auto accident. But I've seen my time's up. And
Thank you, Mr. Cerucci.
Thank you very much.
Mr. Elkind?
Good morning. May it please the Court, I'm David Elkin, representing Boston Gas. Fundamentally, this case is about one issue, the interpretation of the insurance policy. That should be the starting and ending point here.
I think you may have at least 6 votes on that.
Okay, thank you.
Now
And I'm
how,
going to spend a
what
lot-
that means, however,
Right, and I will spend a lot of time on that because courts in Massachusetts and in other jurisdictions that follow the same rules of construction all have reached an all-sums result. The problem with Century's argument is they conflate 2 separate and distinct issues. The first issue you've already resolved. What must happen during the policy period to trigger coverage? It's property damage during the policy period. But the question before this Court is what is the scope of coverage, the amount of coverage provided by a triggered policy? And that is in the insuring agreement. Its language he barely mentions. It's ultimate net loss, the sum actually paid by Boston Gas for its liability. These are excess policies and primary policies. It's all sums. It's the policy language. It's not a probable fiction. And it's a matter of contract.
What do you do about the language to which this policy applies, though?
The language in the insuring agreement to which this policy applies refers to the entire policy. The insuring agreement, the conditions, the exclusions, and so forth. What they're quoting from is a separate provision, which is the triggering mechanism, which provides that, for example, property damage happening anywhere in the world during the policy period triggers coverage. It doesn't define anything, and it certainly doesn't define the language in the insuring agreement to which this policy applies. That language does not affect the scope of coverage, and it's not an allocation provision. It's very instructive that Century specifically provided for allocation for defense provisions. It's on the same page as the insuring agreement, and they have a formula for defense, but they don't have any allocation formula or any allocation for indemnification. By the way, this all sums or the sum actually paid language does not assume that all damage happened in one policy period. It assumes that damage happened during the policy period and that Boston Gas is liable in part because of that damage. The fundamental issue here is these are liability policies, and the ultimate net loss language, or all sums, tracks Boston Gas's liability. If there was property damage throughout but no liability, these policies wouldn't apply. But if you look at the verdict form,
just say that for me again.
if property damage happened throughout,
Right.
but there was no liability, these policies wouldn't apply. But here we have the jury specifically finding property damage during the policy periods, and in question 8 answering that Boston Gas was liable for $6.2 million because of that property damage. The ultimate net loss provides they will pay the sum actually paid by Boston Gas for its liability.
Could you explain to me, you said in every case where policies like this have been interpreted, the all sums approach is taken. What is the difference between the policy here, for example, and the one at issue in New Hampshire, in the Energy North versus Underwriters Lloyd's?
Language essentially is the same, but in New Hampshire...
They came out the other way.
It did go the other way. What I said is all courts that apply the rules of construction that this court has espoused, and that's in Hakeem. If the policy language is clear, you interpret the policy as written.
Well, New York says it interprets the policy as written as well. Doesn't New York come out the other way on a very similar policy?
New York basically said there should be an allocation. We're not sure what reason. But let me mention, Justice Corder, you bring up an important point. The courts that by and large have allocated all have done so, and they've read out or ignored the all sums ultimate net loss language, which is contrary to Massachusetts law, and they apply so-called equitable principles. Well, under this court's holdings, both in Hakeem and Bellevue Industries, those considerations shouldn't apply if the language is clear. Nobody's arguing the language is unclear here. If you're going to consider the equities,
Well, I mean,
however...
they're not arguing the language is unclear, but as I take Century's position, they're saying that you are ignoring one provision, and you say they're ignoring another provision.
Well, Your Honor, they're saying that we're not ignoring any provision. Their provision that they rely on is essentially a triggering provision.
I
It tells-
understand that, yeah.
We're not ignoring that at all, but once the policy is triggered, the scope of coverage, the extent of coverage is in the insuring agreement. It's ultimate net loss here. It's all sums in primary policies, and that tells you the amount of coverage that a trigger policy must provide.
What is,
I'm sorry.
can I just follow, why, I mean, we're not getting into intent, but I'm also trying to figure out rational rules. When was these policies were issued, the Century policies were issued in the 50s and 60s?
51 to 69.
So, but long before we had circular and long before we started.
That is correct. However,
No,
and
no,
this
no.
is-
I just want to just position myself. Okay.
no one could anticipate this.
No, I
liability.
understand that. I mean, and there are lots of cases that, but so taking it out of these troublesome quote asbestos environmental spillage, let's just leave it to environmental spillage cases. In the usual business situation, why would an insurer write a policy that has a time limitation and then have the ultimate net loss? I mean, in other situations.
It's a very good question, Your Honor, and there's two things I want to point out. First of all, because those are two separate issues. The time limitation, if you will, tells you what must happen during the policy period to trigger the coverage, to implicate the policy.
Yeah, no, I
That's
understand.
trustees of Tufts.
But why would somebody buy onto an ultimate net loss? What's the business purpose of that? I mean, isn't that an
From the
enormous?
insurer's point
Well,
of view.
from the
From the
insurer's
insurer-
point of view is because they wanted to sell broad coverage because they wanted to collect the premiums. In fact, in this case, let me back up a bit. Century Indemnity was INA, the leading gas utility insurer. And the language here was no accident. Their lead underwriter, Jack Stoke, testified that he was aware of the potential for long-tail claims where the claim follows the end of the policy period by many years when he wrote these policies and put in the broad occurrence-based language. This was no accident. This was language drafted by Century. And by the way, Century imposed the self-insured retention. Boston Gas didn't choose to do so, although the jury didn't find that there was a self-insured retention from 51 to 1960. Now let me mention, Century reads out the ultimate net loss clause, the basic insuring provision. Under Massachusetts law, you cannot do that. Rubenstein and Chicago Bridge both consider all the policy language, and respectively, Your Honor, I believe that Chicago Bridge's language is virtually identical to the language here. In Chicago Bridge, the language was the total sum as opposed to the sum, and both policies had what are called non-accumulation clauses. Here, it's condition 6. What it states is that if multiple Century policies apply to a claim, we only get the highest limits of any of those policies under one policy. That specifically contemplates that it will cover property damage before and after the policy period, because a provision would mean nothing if it didn't involve multiple policies at the same level. It's part of the other insurance clause. The other issue that came up about future costs, the policy provides dollar limits per occurrence. There's no question that the contamination at this site arose from one occurrence. That's always been the case. That's been the rulings and so forth. Therefore, every dollar that arose out of the contamination from that occurrence is covered by the
That's
policy.
an occurrence that's occurring during the policy period.
No, it's a separate issue. Property damage
Well, that's the
happens.
definition of occurrence.
The
As
occurrence,
during the policy period as part of the definition.
it is. It implicates two issues. The occurrence is also the causative event. The occurrence is an accident, including continuous or
Yes.
repeated conditions,
Right, but
which results in property damage.
But I take it, one way of interpreting that is that if you have, maybe somebody made this example, if you have a lot of different wells that are separately polluting, within the policy period, that would be considered as one occurrence.
And the language here says, all exposure from continuous or repeated exposure to the same conditions is one occurrence. And all of the conditions, the gas plant pollution, is an occurrence under Massachusetts law and under most jurisdictions' law. So once they have to pay property damage because it's happened during their policy period and there's their liability for Boston Gas because of that, they have to pay under the ultimate net loss clause, thus some actually paid by Boston Gas for that occurrence.
Let me ask you this, because these are everybody seems to agree on one point, which is these were manuscript policies, right?
Right, that's right.
So I infer from that these were jointly negotiated terms.
Not necessarily. And in fact, there's no evidence of that. Manuscript policies in this context just means they were specially typed by Century instead of perhaps using the standard forms. But the language at issue is standard form language. There's no evidence of any negotiation. In fact, let me go back to an issue. If this court is going to consider the equities, contrary to Hakeem and Bellevue Industries, they all favor Boston Gas. Century
No,
trots out-
it was really a question of what you do with ambiguities if you find
Well,
any.
there's no evidence of any negotiation. In fact, Mr. Stoke testified, the underwriter, that this was language chosen by Century. And in fact, we introduced at trial a similar policy sold to another utility to demonstrate the limits of liability of the missing policy. There's no evidence of negotiation at all.
So what's the point of all this? We're going to have another complicated, a second series of litigations between the insurance companies to allocate out between themselves?
Well, Your Honor, let me explain what the alternative is. And this is their argument that it's fair and efficient to do it in one case. First of all, we believe that those aren't considerations under Hakeem, where the language is clear. But what this would cause is a policyholder like Boston Gas to sue all of its insurance companies in one action, wait for all of their contribution rights to be sorted out before getting one dime from Century. That's not the bargain it struck. Now, Boston Gas could afford to do this. Smaller policyholders will go bankrupt. If there's an environmental claim, the Commonwealth is going to be left holding the bag. If it's a mass tort claim, the claimant will be left without compensation.
Okay,
That's not fair and efficient.
But to respond to Justice Fina, what does Century have to do, in your view, now?
Century has
If we
three
go-
rights. First of all, it purchased massive amounts of reinsurance for this claim. In fact, the reinsurance may cover its entire liability. It can pursue that. It can pursue contribution rights from other insurance companies whose policies also are triggered. And one issue that has not been resolved, it can argue to the lower court that it is entitled to a credit for Boston Gas's prior settlements with other insurers. And that will be an issue of contention. But it certainly has rights, and it's not going to be left holding all the liability. In fact, after its reinsurance gets paid, it may have no liability. Now, let me just turn to the other issue about the scope of an allocation.
Does Century agree with you about the rights that they would have?
I believe they agreed that they have reinsurance. They testified as such. Contribution rights he mentioned. There would be a disagreement as to whether they're entitled to a settlement credit. Let me briefly mention one of the settlements repurchased the entire policy. It was sold back. It didn't just deal with this claim. The other settlement dealt with all of Boston Gas's environmental property damage claims. So it's apples and oranges, but they can certainly make an argument that some
And they're
of those
going to have to
settlements
fight
should be
about how
apportioned.
it gets allocated.
Right, and they can make the argument to the lower court. Now, Century's argument about how allocation should be performed is to say it should be performed across all periods of damage. The only appellate court that has allocated that has reached such a draconian result is Minnesota. Other courts have placed limits on the allocation, no allocation for uninsured years and so forth, or where insurance couldn't be purchased. But then Century says, well, there should be a rebuttable presumption, and the lower courts are free to deviate from that. It's not going to promote judicial efficiency. This court instead should read the policy as drafted, require them to pay ultimate net loss up to their policy limits, and then seek reinsurance contribution rights or settlement credits to limit their own liability. Now let me respectfully turn to the last issue about self-insured retentions when multiple policies are triggered that are sold by the same insurance company. The answer to that, again, is in the policy language. The policy says once Boston Gas pays the self-insured retention in that policy, Century will pay the occurrence limits of that policy, not that Boston Gas has to pay the retention in other years. A contrary result, as they concede, would be an allocation in disguise. And Chicago Bridge handled this exactly right. In that case, there were 3 sites, so therefore 3 occurrences, and they required the policyholder to pay 1 self-insured retention for each occurrence and then to get the coverage on the per-occurrence limits. And we believe that's the proper result, again, under the policy language.
Mr. Elkin, there was one little question, and maybe you can sort it out, and maybe it was late last night when I was trying to figure it out, but you make an argument in your brief that because the jury found that property damage happened during each of Century's policy years, but not in any other years, and I understand they've addressed that point, the factual premise of the first certified question is non-existent.
We did make that argument, Your Honor, and that
I
obviously...
just couldn't figure out what it was.
Well, it's a very complicated issue. We certainly concede that we argued that there was ongoing property damage. The
Right.
jury found what they found. One concern we have is if the court decides that the issue is not ripe because only the Century policy periods are implicated, the First Circuit, based on its earlier ruling, may issue an allocation ruling that will conflict with the decisions of the Massachusetts Court of Appeals, and you may have a split of authority between federal courts interpreting Massachusetts law and at least intermediate state appellate courts interpreting Massachusetts law, which would lead to an unusual race to the courthouse.
Okay. Thanks very much.
Thank you.